We are thankful, sir, for moderating this session. Now I'd like to request Surya sir to take over.
Thank you, Dipanshu. Very good morning, sir. So it is a great honor for WBNUJS, who has got this opportunity to host you. I, on behalf of our Vice Chancellor, sir, the entire faculty, the staff at NUJS, welcome you. We are really great, deeply honored that you accepted our invitation, sir. So the Society for Advanced Criminal Justice works on the various areas of the latest topics of the criminal law, where students are the members. They publish blogs, arrange quizzes, organize webinars, seminars, as well as workshops. We have hosted a number of legal luminaries in the past as well. We also seek to get your support and help for the society to in the coming years. So now coming to the today's topic, the advancing criminal justice in the present and the future. So it makes me think without reflection of the past, we cannot think about the present and the future criminal justice system and how it would work along with its stakeholders, the primary stakeholders, as we are all aware, the victim, the accused, the legal service institutions, the court, as well as the society who also contributes in the process of victimization of all the stakeholders of the criminal justice system. I also like to add about the present situation, which is concerned about the huge backlog of cases, which is also a reason for our justice delivery system, the growing demand for victim rights, the also the reason for which the victims should be considered as one of the mediums to enable access to justice for them, and also the other stakeholders how to work in coordination to enable the justice delivery system an effective one. So with these few notes, I leave the floor open to you to as we are all eagerly waiting to hear you. Thank you, sir.
Thank you very much indeed. I'm very grateful for this opportunity to share my thoughts with you on a very relevant and important topic, particularly when we are beset with this pandemic called COVID. I want to begin with the inequities which have been noticed in the criminal justice system elsewhere as a starting point for reflection. In 1964, the American Attorney General, Robert Kennedy, he testified before a subcommittee of the US Senate Judiciary Committee to advocate for legislation to reform the bail system in the United States. He began his remarks by saying that the rich man and the poor man do not receive equal justice in our courts. And in no area is this more evident than in the matter of bail. He illustrated the point with two instances. The first was a person who was forced to stay in jail awaiting trial for a minor crime because he could not afford bail. His case came to trial after 207 days and he was acquitted. The second was a case of a man from Pennsylvania who could not raise $300. He spent 54 days in jail awaiting trial on a traffic offense. In New York, a gentleman by the name of Daniel Walker was arrested on suspicion of robbery. He spent 55 days in jail for want of bail. He lost his job. His car was repossessed. His credit was destroyed. And his wife had to move in with her parents. And later, he was found to be the victim of mistaken identity and released. But it took him another 4 months simply to find another job. This really tells me that there is a lot of substance in what a very famous philosopher, Tocqueville, said about justice. He said, "The opinion of mankind clings even to the appearance of justice long after the substance has evaporated. It lends bodily form to the shadow of the law." Now, let me come to a second perspective. This was Robert Kennedy in 1964. But see, a few years later, the situation was still serious. And in an extraordinary article, which I would commend all of you to read, because it is an article of such great depth, inspiration, and commitment, which shows that what is the level of engagement which is required to understand the effect and impact of the criminal justice system. This is an article written by President Barack Obama. And I read the first paragraph of this article. And he says, "Presidencies can exert substantial influence over the direction of the US criminal justice system. Those privileged to serve as president and in senior roles in the executive branch have an obligation to use that influence to enhance the fairness and effectiveness of the justice system at all phases. How we treat citizens who make mistakes, even serious mistakes, pay their debt to society, and deserve a second chance, reflects who we are as a people and reveals a lot about our character and commitment to our founding principles. And how we police our communities and the kinds of problems we ask our criminal justice system to solve can have a profound impact on the extent of trust in law enforcement and significant implications for public safety." In that detailed article, he also acknowledges, and it is a very poignant sentence, "It takes young people who made mistakes no worse than my own and traps them in an endless cycle of marginalization and punishment." Later, he says, "As a state legislator in Illinois, I worked with law enforcement and civil rights leaders to push for reduced sentences, videotaped police interrogations, and other reforms, including legislation in favor of second chances and against profiling." This is a very important statement. And the number of steps which were taken by President Obama, which he has outlined, indicate that this subject really comprehends a very large part of our social behavior. How do we look at people who commit crimes? How are they meant to be afforded due process? How are they meant actually to be treated as human beings under the Constitution? How are they meant to be tried? These are all very important questions. So I want to begin by saying that as far as India is concerned, justice is an important facet of the administration of fundamental guarantees. These guarantees are fair trial, due process, freedom from illegal detention, and conscious regard for personal liberty. The relevance of criminal justice in contemporary times is occasioned by a large amount of state power which can be used for the purpose of setting the law in motion. The Indian Constitution promises justice and the rule of law. The relevance of criminal justice is also occasioned by the fact that it leads to stigmatization and exclusion. It also leads to citizens who are in conflict with law. I will touch upon this a little later. The very basis of the Constitution must be understood. This Constitution was enacted to overcome unevenness which existed in society prior to the coming into force of the Constitution. The unevenness was occasioned by caste, by backwardness, by poverty, and lack of education. That uneven society was the society to which the Constitution lent an assurance, and the assurance was that there would be no stigmatization, there would be no exclusion, there would in fact be a respect for rights. Thus, the very basis of the Constitution was to endow an accountable power structure with a fair-minded administration of laws. The way in which criminal justice is administered is a measurement, in my view, of the rule of law consciousness in the society, and it is to be measured not by platitudes, but by day-to-day practices which are evident on the ground. There has been no shortfall in the fundamental understanding as far as the jurisprudence in criminal justice is concerned. We know it is adversarial, but yet we have always honored the fundamental principles which are embodied in the Declaration of Human Rights and also the other international covenants, that a man is presumed to be innocent, and we believe that an offense must be proved beyond reasonable doubt. We also know that bail is meant to be the general rule. Refusal is its exception. But we have to see, how does this come to manifest itself in real terms? In real terms, we have to ask ourselves a question. Was this a fair prosecution? Was there an overstatement in the charge sheet which needed to be corrected by a long-ending and protracted trial? Were there legitimate objections which could be urged for granting bail or to oppose bail? Was there a fair representation of the accused, particularly when he belonged to the weaker sections of society? It is only by rigorous social audit that we can see that these ground realities will require tremendous reappraisal. In fact, some of the work done by researchers, which I'll have an occasion to refer to, indicate that these concerns are extremely valid. Courts of justice are meant to be accessed, and under the Constitution, they can never be closed. It is in the essential elements of access that we can measure the true administration of justice. Criminal justice, if dispensed correctly, is a means of rightful empowerment assured under the Constitution. India's challenge is not that we do not have adequate principles to direct the manner in which the criminal justice system should operate. We have adequate jurisprudential guidance from the Supreme Court in relation to the various facets of criminal justice: bail, speedy trial, the requirement of legal aid, the presence of a legal practitioner, and various other remedies. But the challenges which face our criminal justice system are in practical terms, and we will have an occasion to deal with them. Now, I believe that, first of all, let us start with 4 points. The first, we must have responsible and independent public prosecutors. These must be prosecutors who are at arm's length from the government. They must have fidelity only to the rule of law. They are, as the Supreme Court described, officers of the law and officers of the court. Secondly, we must ensure equality of arms, and that is by strengthening legal aid and the quality of legal representation which is available. This is an area where I do believe that considerable amount of investment requires to be made. The mere existence of legal aid authorities is again not enough. We need also a certain audit of the authorities, and we have to ensure periodically the goals which are achieved by these authorities. Thirdly, we must take steps towards controlling discretion, which is available across the criminal justice system in the matter of grant of bail and the exercise of inherent power or the inherent jurisdiction of the High Court. Finally, we must attend to certain threats to the rule of law, which can tend to the marginalization of the poor and greater criminalization of the marginalized themselves. As far as the role of public prosecutors is concerned, they are appointed on the recommendations of the High Court. And public prosecutors are appointed in sessions courts on the recommendations of the sessions judge. Public prosecutors can also be appointed by the government for conducting any specified case or class of cases. Some states have set up directorates of prosecution, but as the Law Commission noted in its 154th report, a common complaint was that there were insufficient prosecuting officers and prosecutions were not being conducted efficiently. The second complaint was that prosecutors do not prepare cases carefully, and the quality of prosecutions was poor. There are, of course, exceptions. The states have set up varying organizational structures for prosecution of crimes. They're typically housed in their ministries under, who control the Directorate of Prosecution, but there is no uniformity in structure across the states. So even though there is one code of criminal procedure, crimes are prosecuted by directorates of prosecution with different internal structures. Minimum standards are necessary. Structural standards of minimum components are necessary for the independence and efficiency of directorates of prosecution. Justice Venkatramaiah in Shivnandan Paswan had laid down the 8 principles which should inform the court in evaluating a prosecutor's decision to withdraw a case. And he concluded that the court has a responsibility and a stake in the administration of criminal justice, and so has the public prosecutor, its minister of justice. Both have a duty to protect the administration of criminal justice against possible abuse or misuse by the executive by resort to the provisions of Section 321 of the Criminal Procedure Code. The independence of the judiciary requires that once the case has traveled to the court and its officers alone must have control over the case and decide what is to be done in each case. Justice Chinnappa Reddy again summed up these propositions later in Rajinder Kumar Jain. Under the scheme of the code, prosecution of an offender for a serious offense is primarily the responsibility of the executive. The withdrawal from the prosecution is an executive function of the public prosecutor. Most importantly, he said, the discretion to withdraw from the prosecution is that of the public prosecutor and none else, and so he cannot surrender that discretion to someone else. The government may suggest to the public prosecutor that he may withdraw the prosecution, but none can compel him to do so. The public prosecutor may withdraw from the prosecution not merely on the ground of paucity of evidence, but even on other relevant grounds to meet the broad ends of public justice, public order, and peace. The broad ends of public justice will certainly include appropriate social, economic, and we add political purposes sans Tammany Hall enterprises. The public prosecutor is an officer of the court and is responsible to the court. The court performs a supervisory function in granting its consent to withdrawal. The court's duty is not to reappreciate the grounds which led the public prosecutor to request withdrawal from the prosecution, but to consider whether the public prosecutor applied his mind as a free agent, uninfluenced by irrelevant and extraneous considerations. The court has a special duty in this regard, as it is the ultimate repository of legislative confidence in granting or withholding its consent to withdrawal from the prosecution. I believe that if attention is paid to the subject of appointment of independent public prosecutors who have an opportunity to apply their mind whether cases must actually go to trial or whether charge sheets should be laid, a considerable degree of burden itself would be lessened from the docket of the courts. In England, Lord Bingham summarized the duty of prosecuting counsel as being to ensure justice is done without regard to winning or losing a case. In the famous 2002 case called Randall versus the Queen, adopting the Canadian Supreme Court's reasoning in an earlier 1954 decision, the duty of a prosecuting counsel is not to obtain a conviction at all costs, but to act as a minister of justice. The prosecutor's role was very clearly described by Justice Rand in the Supreme Court of Canada in Boucher versus the Queen. It cannot be overemphasized that the purpose of a criminal prosecution is not to obtain a conviction. It is to lay before a jury, in India it is the court, what the Crown considers to be credible evidence relevant to what is alleged to be a crime. Counsel have a duty to see that all available legal proof of facts is presented. It should be done firmly and pressed to its legitimate strength, but it must also be done fairly. The role of prosecutor excludes any notion of winning or losing. His function is a matter of public duty, which in civil life there can be none charged with greater personal responsibility. It is to be efficiently performed with an ingrained sense of the dignity, the seriousness, and the justness of judicial proceedings. I must share with you that one of the greatest lawyers of this country, perhaps one of the all-time great lawyers in the field of criminal law, the late Mr. Ram Jethmalani, used to frequently cite this decision when he noticed what was prosecutorial overzealousness to obtain conviction or to keep back evidence from court. A crucial facet of these functions is the need for putting in place transparent procedures that only genuine cases are brought to trial. This would itself ensure that the system is not abused, and we would stem the tide of cases flowing into the docket. The appointment of public prosecutors, both with ability and the competence to exercise discretion, is vital to the rule of law. Men who will find the courage to sanction a withdrawal on justifiable grounds are the need of the hour. Their courage must never become the target of suspicion and accusation. The role of public prosecutor is important. He is the first point of check. He examines the material collected by the investigating officer. He must ensure that an innocent person is not being harassed, and that is very easy for a public prosecutor to determine on the basis of the material collected by an investigating officer. At the stage of filing the charge sheet, there must be proper application of mind. The second, equality of arms. This is very important in my view. And unless and until this equality in the matter of representation is ensured, the fundamental guarantee of justice, which is in the preamble and the rule of law, will not be delivered. The directive principle under Article 39A of the Constitution, which provided that the state must ensure free legal aid, made a clear connection between legal aid and a system which promotes justice. No wonder, in the famous judgment in Hussain Ara Khatun, the Supreme Court said that the right to free legal services is clearly an essential ingredient of reasonable, fair, and just procedure for a person accused of an offense, and it must be held implicit in the guarantee of Article 21. This is a constitutional right of every accused person who is unable to engage a lawyer and secure legal services on account of reasons such as poverty, indigence, or incommunicado situation, that the state is under a mandate to provide a lawyer to an accused person if the circumstances of the case and the needs of justice so require, provided, of course, the accused person does not object to the provision of such lawyer. I must add that when it comes to the protection of fundamental rights, including the substantive guarantees under Article 21, there cannot be compulsions of what are called fiscal limitations. This is a little essential because, in my view, if you are depriving a person of his liberty, then there is a corresponding obligation to ensure that he has a fair representation in the event he is one who is qualified to receive it. This equality is very necessary and imperative, and as would be seen from practical experience, that more often than not, due to lack of representation, convictions have come. In order to put this into effect, the court emphasized an urgent necessity of introducing a dynamic and comprehensive legal service program with a view to reaching justice to the common man. It was of the view that this is not only a mandate of equal justice implicit in Article 14 and a right to life and liberty conferred by Article 21, but also the compulsion of the constitutional directive embodied in Article 39A. The court also adopted the reasoning of two Supreme Court cases. One was Gideon. In Gideon's case, Justice Black argued that the right to fair trial included a right of the poor just as of the rich to be represented in court by a lawyer, to arrive at the conclusion that there can be no equal justice where the kind of a trial a man gets depends on the amount of money he has. He reasoned as follows: that government hires lawyers to prosecute, and defendants who have the money hire lawyers to defend are the strongest indications of the widespread belief that lawyers in criminal courts are necessities, not luxuries. The right of one charged with crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but is in ours. From the very beginning, our state and national constitutions and laws have laid great emphasis on procedural and substantive safeguards designed to assure fair trials before impartial tribunals in which every defendant stands equal before the law. This noble ideal cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist him. I want to add a footnote here. In India, we must bear in mind that the foundations of our constitution were particularly intended to assist those who were deprived of rights, those who were not conscious of their rights, those who were not sufficiently empowered to seek access on the basis of those rights. Therefore, we must bear in mind that a simple facial statement of inclusion or universalization through legal aid is not sufficient. For India, the journey is even stronger. It is even more pronounced. And that journey is a journey to make sure that it is of a substantive character. I make this point because the investment which is required in legal aid will have to be measured according to the needs and the realities which exist in our present system. The second American Supreme Court judgment was the famous judgment rendered by Justice Douglas in Argesinger versus Hamlin. And he said The right to be heard would be in many cases of little avail if it did not comprehend the right to be heard by counsel. Even the intelligent and educated layman has small and sometimes no skill in the science of law. If charged with crime, he is incapable, generally, of determining for himself whether the indictment is good or bad. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial without a proper charge and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise inadmissible. The Gideon principle was underscored in Hussein Ara Khatun and also in Hoscott, where Justice Krishnaya said that there could be no equal justice without the guarantee of a lawyer. And in his imitable words, judicial justice with procedural intricacies, legal submissions, and critical examination of evidence leans upon professional expertise, and the failure of equal justice under the law is on the cards, where such supportive skill is absent for one side. Our judicature, molded by Anglo-American models, and our judicial process engineered by kindred legal technology, compel the collaboration of lawyer power for steering the wheels of equal justice under the law. Detention on shaky foundations has plagued the Indian criminal justice system. This is a very important point because the court always placed a great deal of regard, in fact, deference to what is called personal liberty. The court addressed this issue on more than one occasion since the 1980s. In fact, I remember a case which came up during the summer recess, very close to the present date at that time. Sant Longowal, a very eminent Sikh leader, was taken into custody. He was detained under a preventive detention order. A writ petition was filed for habeas corpus, and it was mentioned before the registrar, and this is something which history will bear out. At that time, the summer recess was the time when the maintenance work in courts would be undertaken, except in certain courtrooms. But because this was a habeas corpus matter, a special bench was constituted, and the judge who was sworn in on that day, a few hours earlier, Justice Kale, joined the bench, and the court issued ruling on my side straight away on the writ petition. I'm mentioning this only to indicate the solicitude with which courts have treated matters of personal liberty. In Hussein Ara Khatun, under trial prisoners who were charged with offences but bailable, still in jail, was dealt with in the most appropriate way, because the court said they are possibly in jail because no application for bail has been made on their behalf, or being too poor, they are unable to furnish bail. This aspect of being unable to furnish bail because of lack of sureties has also actually become an obstacle in the release of poor prisoners, particularly people who have been detained under statutes like vagrancy laws, but yet unable to get out of the shackles of confinement because they were unable to offer sureties. It has taken judicial intervention to arrive at the conclusion that they can be released straight away without even a surety. But it required continuous effort and intervention by the court. The bail jurisprudence in the 80s is also relevant because in Motiram, the court said the poor cannot be asked to produce sureties to seek bail. But in reality, it has been noticed that people languished in jail and ultimately successive orders had to be passed. The next is the overcrowding in prisons. This is an important subject because you have a large number of under trials. We will look at some figures later. But the overcrowding in prison has been a major issue in our criminal justice system. It has been an issue in other jurisdictions as well. It has been an issue in the United States, as you would see in President Obama's article, that the amount of money which is spent in incarceration of people is so utterly disproportionate to the needs of the situation. And this problem was brought again to the attention of the court in June 2013, when Justice Lahoti, an eminent former Chief Justice, noted the inhuman conditions in 1382 prisons in India, as reflected in a story which was published in a Hindi paper called Dainik Bhaskar on the 24th of March 2013. The letter highlighted 4 problems. 1, overcrowding of prisons. 2, unnatural death of prisoners. 3, gross inadequacy of staff. And 4, available staff being untrained or inadequately trained. The per capita spending on legal aid in India is very insubstantial. It is very, very insubstantial. It is virtually less than a rupee, according to reports which have been released by the Commonwealth Human Rights Initiative in 2018. They said it was 75 paisa. Other findings of that study include the fact that there is no scheme to provide legal aid at police stations. There is also something to be noticed, that the funds which are allocated to legal services authorities are also underutilized in many of the states. There is a research paper which I came across, and I found that the paper was very useful, authored by 2 scholars, Gitanjali Prasad and Ranal Satish, which illustrated multiple points of disconnect: marginalization, bias, inadequate legal protection, poor data maintenance. If these features are obtaining, which is what the research paper says, and their studies are based on data, in my view, the occasion is not far away that the Supreme Court must commence a suo motu proceeding to address these concerns. The reason why I say that is, and I will deal with the situation relating to COVID separately. The courts also have, under our Constitution, a transformative role. And I wish to say this with respect, that the jurisdiction vested in constitutional courts by our Constitution is to enable courts to be proactive in ensuring that justice is actualized. The actualization of justice is why Article 32(1) uses the word "such other writs as may be necessary." The plenitude of the power which is vested in the courts to do justice is geared towards ensuring that people get a fair-minded, even-handed administration of justice, whether it be in the trial, whether it be at the stage of the appeal. I submit that in such a proceeding, the court may consider issuing a comprehensive set of directions. These are to correct deep-seated, continuing societal issues which translate themselves as obstacles to justice realization. Professor Pandey, who was, again, I was taught by him, I had the privilege of being taught by him, he used the expression invisibilization of the poor. So apart from stigmatization, you also have the invisibilization of the poor. Both Professor Upendra Bakshi and Professor Pandey were great inspiration to students of law to gauge the very deeply class-structured society with the higher and privileged classes enjoying innate advantages of opportunity and education. Article 22(1) provides that no person who is arrested shall be detained in custody without being informed, as soon as may be, of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. The use of the expression legal practitioner in the chapter on fundamental rights is not only implicit in Articles 14 and 21, but is also explicit in 22. And this indicates that an independent legal profession, which will be necessary to be harnessed for the purpose of protecting the personal liberty of citizens, is also a bedrock of constitutional values. An independent legal profession and the members of the bar are an integral part of the justice delivery system. They have to be independent by training, never willing to succumb to pressure, and they have to speak up and evaluate the cases of their clients or the litigants. This constitutional right, which assures legal practitioner, also means effective legal representation. I say this in the context of the Strickland test. That was a case which came up for consideration in the United States. Justice Sandra Day O'Connor observed in the judgment that if a criminal defendant's attorney's performance fell below an objective standard of reasonableness, then the constitutional right which was sought to be represented by a lawyer would be said to be violated. Another decision in the same year as Strickland was United States versus Chronic. There, the US Supreme Court held that affirmative government interference in the representation process and lawyers' failure to subject the prosecution's case to meaningful adversarial testing could violate a criminal defendant's right to fair trial. Justice Stevens reasoned as follows: the right to the effective assistance of counsel is thus the right of the accused to require the prosecution's case to survive the crucible of meaningful adversarial testing when a true adversarial criminal trial has been conducted, even if defense counsel may have made demonstrable errors. The kind of testing envisioned by the Sixth Amendment has occurred. But if the process loses its character as a confrontation between adversaries, the constitutional guarantee is violated. As Judge Wyszynski has written, while a criminal trial is not a game in which the participants are expected to enter the ring with a near match in skills, neither is it a sacrifice of unarmed prisoners to gladiators. In the case relating to Ajmal Kasab, Justice Aftab Alam noted that it could not be argued that Article 22(1) was a simple enabling provision, but it was in fact a comprehensive right to appropriate legal representation. As far as bail jurisprudence is concerned, in my view, the perception that magistracy is unwilling to grant bail and that matters should be taken up to higher courts must be dispelled. Because magistrates, according to the judgments of the Supreme Court, and again Justice Krishnaya noted, what is often forgotten and therefore warrants a reminder is the object to keep a person in judicial custody pending trial or disposal of an appeal. And he quoted the words of Lord Russell. I observe that in this case bail was refused for the prisoner. It cannot be too strongly impressed on the magistracy of the country that bail is not to be withheld as a punishment, but that the requirements as to bail are merely to secure the attendance of the prisoner at trial. In my view, if discretion is exercised appropriately, the dockets which pile up for bail on higher courts would be also substantially relieved. The next is, of course, release on personal bonds. And I've already mentioned that the Supreme Court held that under trials should be released on personal bonds. Even the Law Commission made a recommendation that the majority of arrests which were made are really for bailable offenses. And there is a correlationship between the number of arrests which are made and the high under trial population. In the suo motu action recently taken by the Supreme Court, in re-contagion of COVID-19 virus in prisons, the Supreme Court noted the bitter truth of the overcrowding in our prisons and took note of the alarming statistics. There are 1,339 prisons in this country, and approximately 4,66,084 inmates inhabit such prisons. According to the National Crime Records Bureau, the occupancy rate of Indian prisons is at 117.6%, and in such states as Uttar Pradesh and Sikkim, the occupancy rate are as high as 176.5% and 157.3%, respectively. In its following order on 23rd March 2020, the Supreme Court issued welcome directions for the decongestion of prisons. It directed the setting up of a high-powered committee by the state government to determine which classes of prisoners could be released on parole or could be admitted to interim bail. It suggested the release of under-trial prisoners and convicts for offences for which the prescribed punishment was up to 7 years or less, with or without fine, and where the prisoner has been convicted for a fewer number of years than the maximum, the same could be considered. And this direction, in my view, has been a very welcome direction, considering the problem of over-congestion of prisons. I now deal with the subject of the inherent jurisdiction of the court. The inherent jurisdiction of the court is really to further the ends of justice. If the legal process has been subjected to abuse, in my view, a court has jurisdiction under 482 to interfere. Secondly, if there are civil liabilities or breaches of a contract which are being fastened with the color of an offense like a criminal breach of trust, cheating, conspiracy, the court must interfere in its inherent jurisdiction. No wonder the Supreme Court deprecated this practice and said, any effort to settle civil disputes and claims which do not involve any criminal offense by applying pressure through criminal prosecution should be deprecated and discouraged. In fact, I believe that the exercise of fundamental rights is fully protected under the Constitution. The statutes relating to offenses are not intended to curb legitimate freedoms. Democracy is founded on the bedrock of freedoms. It will be a negation if the state exercises statutory powers in criminal law to stifle speech, action, or a voice of dissent. The world of ideas are meant to survive contradictions and opposing points of view. There is a fundamental threshold that the criminal process must neither be an opposition nor must it be an interference in respect of fundamental rights. We do have a pending legislation in the form of DNA technology use and application regulation bill. In my view, it will require very careful consideration, and particularly the content relating to profiling and possibilities of discrimination. With reference to new technologies, in Selvi versus State, the court said no to brain mapping, lie detector tests, and narco analysis as offending the right against self-incrimination. And in 2019, the court dealt with a voice print identification. Thus, we come to another point. There is a need to be clear about proof beyond reasonable doubt. The distinction between balance of probabilities and proof beyond reasonable doubt is indeed of great significance in the administration of criminal justice. In matters which are to be proved beyond reasonable doubt, every relevant fact which leads to the commission of the offense needs to be conclusively proved. Without it being proved, the offense cannot be said to have been committed. Let us look at some official data. A total of 50,74,634 cognizable crimes were recorded by the National Crime Records Bureau in 2018 alone. Of these, 31,32,954 pertain to the Indian Penal Code and 19,41,680 were offences covered by special and local laws. The data on arrests, conviction and acquittals are also relevant. A total of 5,25,188 persons were arrested under 5,45,502 IPC crimes. A total of 3,91,024 persons were charge sheeted. 83,552 persons were convicted. 74,679 persons were acquitted, and 5,985 persons were discharged. A total of 3,07,070 persons were arrested under 2,56,765 crimes pertaining to special and local laws. A total of 3,02,921 persons were charge sheeted. 1,71,591 persons were convicted. 22,428 persons were acquitted, and 1,979 persons were discharged. Thus, these rates clearly indicate that the conviction rates are low. In respect of metropolitan cities with a population greater than 2 million, only 38.1% of murder cases which are tried lead to a conviction. Of course, inferences can be drawn from low conviction rates, but where there is a high rate of charge sheeting, then the issue arises whether cases which were unfit for prosecution proceeded further. According to the National Judicial Data Grid, 2,36,20,858 criminal cases are pending across the system as of yesterday. Of these, some 1.5%, that is 3,64,666 cases, have been pending for over 20 years. The following principles, my friends, are therefore germane. criminal justice system is not meant to encourage a wild goose chase. It is not meant to be used in civil liability. It is not meant for suppressing dissent. And therefore, the courts must consider taking charge of these cases and craft remedies or methods by which there can be effective disposal. One of the ways in which this could have been dealt with was paying attention to the case at the stage of committal. But the provisions relating to committal have not been viewed more than a mere irregularity, as a consequence of which committal has become absolutely automatic. I need to add another point, that criminal justice system involves the protection of prisoners, protection of their bodily integrity. Any complaints in relation to violation of their human existence is itself a basis for a constitutional remedy. I need to mention that the existence of the National Human Rights Commission Act was to protect, advise, monitor, and educate human rights, but it is not to supplant adjudication. It is not meant to circumvent, if I may say so, the access to courts to investigate and deal with issues of constitutional violation. As far as the strength of the National Human Rights Commission is concerned, the Supreme Court has passed directions. It has noticed that many of these commissions have been understaffed. And it is also clear that the Commission has had tremendous workload, and as a consequence of which, even an amendment has been brought in the year 2019. The Supreme Court referred to the National Human Rights Commission as a toothless tiger in its judgments. But as I said, one has to look positively. What is positive and what can happen is the question. In my view, both the executive as well as the judiciary are always and fully capable of dealing with these areas in a very conscious and goal-oriented way. The Constitution promised a new order for answering historic injustice, and we must know that this involves a struggle against absence. When people disappear, when victims are no longer in existence, does it mean that they are nullities? I wish to say that they are really not nullities. What follows is a reflection on the foundation of that struggle, on the absence, and in particular, on the cluster of issues raised by our efforts to deal with injustices, where absence of the victim has opened a seemingly unbridgeable distance. Distance inflects our efforts to do justice. The changes that accompany the passing of events and persons into the historic past call into question the continuity of responsibility across time and the meaning of restoring a status quo ante under radically changed circumstances. I would therefore certainly hope that where all of us can put together our effort, we can find solutions. There is one last aspect which I must touch before I close, that the administration of justice is an act of compassion and humanity as well. Even in the administration of criminal justice, the possibilities of revival, restoration, and, shall I say, reformation is a very important consideration. This is accentuated when we look at this close nexus between law and poverty. As noticed in the article of President Obama, you will come across various different aspects of engagement with individuals in the justice system. We need to go down and speak to everyone involved in the system. We must have the benefit of their views. The Supreme Court has always acted as a sentinel of fundamental rights. It has the skill to craft new remedies. And I have no doubt that important issues of access to justice will engage the courts and remedies will certainly flow. We must live with conscious optimism and faith in our institutions to be able to deliver what is promised under the Constitution. Thank you.
Thank you, sir. So the lecture was indeed a very one. Sir, we have almost got all the stakeholders which the entire criminal justice has, and how it functions, under its roles, and how one engage with the stakeholders. Just to note a few important points from what you have already discussed. You have rightfully and correctly said that justice is a very important factor, and which is also which is the enabling tool to control our social behavior in the community, to remove the, as rightly pointed out by you, the unevenness which is there in the society. You have very distinctly clarified that why and answered correctly that why the fast track courts, the witnesses are not coming, and also the huge tendency is there in the criminal justice system of India. Because the problem which we have is how the public prosecutes, because he actually is the person who is handling the evidences. The evidences need to be used, like you pointed out, that if discussion with the filing of the charge sheet can be adhered, it will really help the prosecutor to decide that that is not the goal, that whether you are for the conviction or you are for the execution. It is the showcase of the present situation or the circumstance, evidence, fact of the case which has to be laid down before the court. The tactical, the conviction is the court to decide. So the next point which is said is the underperformed legal services. Previously, or the topic also demands that what was the past? In the past, we did not have the legal service institution. Now we have, but after having, the institutions are understaffed. The institutions also needs to be has funds, but which are not utilized. Sir, I am also working on the victim compensation scheme, which the data from the government of India also shows that more than 70% of the funds which were set up after the Nirvana incident is remain unutilized. Now, why we have, or why these funds cannot be utilized? Previously, Section 57 was not thought to be appropriate or adequate enough, but the victim compensation scheme also not to be adequate right now. So you also correctly mentioned that about the prison situation in India. What can be the situation and the current situation of releasing of liberty to 2000 plus murder trials by the Supreme Court of India is a very welcome step. But sir, one thing which came into my mind is that Section 436 of A of CRPC, why is it not operative? Just the way the high powered committee it did or it had to be appointed for along with the help of the state. So from time to time, the prisons are having the statistics and implement these guidelines. We'll hear more from you on that. Also, sir, you correctly mentioned about the provision of bail. That why bail should not be a tool to curtail the freedom of the person within the meaning of Article 14 and 21. Rather, it should be enabling to prevent offense to be committed. Sir, with this, I thank you very much and request your consent so that we can take a few questions from the audiences who are was listening to you. Maybe go ahead, sir.
Certainly, please. I just wanted to mention one thing, which is about COVID-19. Although this is a time of some challenge, I still believe that with the help of technology, to the extent we can, access to justice must be granted. In my view, I know that technology sometimes is not perfect, but with whatever we can do, with also, if I may say so, through proper electronic petitions, which can be sent to the court with submissions, followed by a short hearing, even on Skype or any electronic medium which is effective, some relief will be given. What is important is that COVID-19 also cannot hold up people to claim justice. There are many people who are languishing in jail. They are entitled to some sort of consideration. And therefore, I think the ability to approach courts must be absolutely open. And we have to devise some system. And very simple system is to have electronic petitions with a response from the prosecutor, a short written note of submission, and a short submission, and the court passes an order. Because this is touching upon liberties of a citizen. We have to appreciate that we are not in a state of emergency. We are, of course, it is a pandemic. It is a totally unusual situation. It is a situation where a certain degree of precaution has to be taken. But even then, within the constraints of space and time and whatever technology we have, we should still be able to find a way to petition the courts so that people get relief. You see, courts are ultimately to give relief. They are institutions of redressal. The most important thing is the soul of the Constitution is in redressal. It is redressal which is at the heart of justice. That redressal is to be given only by courts. And therefore, that access to courts is very necessary. And particularly when people are in a state of conflict with the law.
Very correct, sir. You have correctly pointed out that whether access to justice is access to courts. This is the question which needs to be answered from the examples and way the procedures, how it is functioning. Sir, just to appraise your kind self, Justice Joymallo Bagchi in December 2019 has passed an order to connect the magisterial courts in West Bengal along with the prisons with that of the court, so that this functioning and the production of the inmates from the jail can be done in a much speedier way. The huge police bandobast which is required, the safety and the thing can be also be helped the justice professionals to work in an effective manner. So with this, we'll take the first question, sir. Samarth Sharma requests to know that if you could kindly share your views regarding the need and feasibility of gender neutral laws pertaining to sexual offences in India. Am I audible?
Yes. Well, this actually is something which we had an occasion to deal with in the Justice Burma Committee report. And we followed actually international examples that it should be gender neutral. And that is how we actually came to that conclusion. We said it should be, the word should be a person. In fact, we should make it gender neutral. It was my recollection is we dealt with this subject in that in the deliberations of that committee.
Sir. So the next one, our very student Dipanshu Agarwal. So he wants to request you to know that recently the Home Minister has called out for reforms in the criminal law legislation. So, in your view, what would be a few steps or few changes which you like to think is the most important which needs to be considered by the Home Minister?
Yes, I personally feel that one of the jurisdictions where, shall I say, there is a quick disposal of a case is really the French system. In the French system, what happens is that timelines are laid down. So there is a supervision by a magistrate the way a case progresses. But it's partially inquisitorial. But even it is inquisitorial even in our system until it is actually laid before a court. Until that time, the magistrate has some control over what is happening even in regard to an investigation. So if we do have, if I may say so, what are called start to finish cases, or we have time-bound cases, the way in which you actually deal with cases on a time-bound basis itself would be a very good start. The second is, even in relation to tendering of evidence, you don't need to tender enormous amount of evidence or any number of people. You have to only tender what is relevant, what is necessary, more often than not. And when I see the judgment written by a learned judge in one of the cases, he said, I have been conducting this case for so many months and so many thousands of pages were produced before me, but not a single paper of relevant evidence to really support the case. And it is simply a waste of public time, and he closed the case. But the point is, therefore, we need a very controlled and an oriented prosecution, fair-minded prosecution, and at the same time, we have a time limit within which cases have to be disposed of. Similarly, in my view, just as you mentioned about Justice Joymola Bakchi taking that initiative, if high courts also take immediate note of the matters which are pending there, classify them, take statistics, and immediately make benches to make sure that they're all dealt with as quickly as possible. You see, in some high courts in India, the disposal of cases has been absolutely phenomenal. Let us also look at the some areas in some high courts. That is because of a certain procedure which they follow. For instance, in Andhra Pradesh, before its bifurcation, at least I know, that when matters travel from the Sessions Court to the High Court, the appeal would not take more than a year. So within, the record would be made available, counsel had to be ready, and the appeal would be boarded for hearing and would be finished. So therefore, it is all a question of how we manage these areas. They have to be given importance. And we need the assistance of judges who are familiar also with the state, particularly when you have a Chief Justice from outside who may not know exactly the local conditions. We need that cooperation so that how are these cases meant to be dealt with? And who are judges who actually have also familiarity with this branch of law? You see, criminal law needs some training. And I'll tell you, I have witnessed myself some learned judges in the Supreme Court when they had to deal with cases relating to life and death. They said, sorry, we have not done this in our discipline as a lawyer, nor as a judge in the High Court. We don't want to make a mistake. It should go before a judge who is familiar with this branch of law, because there are so many aspects of the law of evidence and admissibility, relevancy, and everything, appreciation. So they said it should go before another court. So those judges who are familiar with this branch of law, who are willing to take it up, benches can be constituted and it can be dealt with, because this is a substantial part of our system. And I think that we should not look for what are called shortcuts by which people are asked to confess. All right, for instance, plea bargain. Now, speaking for myself, although it has been introduced and there was an attempt to have these jail adalats for the purpose of actually having plea bargain, but plea bargain in our society is still got an element of compulsion. And I wish, one of you must read that book on the law of bails in United States, where they talk about one man who refused to accept plea bargaining, and he actually he suffered such torture that finally he took his own life. So therefore, we have to be very sensitive to the requirements of our society. So we cannot just import plea bargain. All right, this will immediately, people will just confess to offenses. No, there must be a fair and even-handed of administration of justice. Therefore, actually, the National Judicial Academy, when Justice Satyabrata Sinha was a judge in the Supreme Court, he had devised the categorization of cases into cases which are, let us say, very, very marginal traffic offenses or cases of less than 2 years, 1 year. How can they be dealt with? We can have any kind of stratification, but it would possibly be dependent upon the local conditions in a particular state. That should be taken into account. So I would say the first thing which needs to be done is to have more prosecutors, and they must be independent. And the message must go as a matter of legal reform that the state is interested in very efficient and fair administration of justice. This is very important because the Constitution stands supreme. You see, the values of the Constitution, of the rule of law, stand supreme. Keeping a person, now just look at that percentage, that you have cases over 20 years. Now you tell me, how would you be able to justify it in terms of constitutional metaphors? Therefore, they need action. These statistics do call for judicial orders and judicial intervention. And wherever necessary, the legislation can be reviewed. Yes, there are two areas where legislation can be reviewed. I do think that the legislation where minimum sentence of imprisonment has been imposed, many of them should be revisited, whether they need any change. Because if suppose you have a minimum sentence of imprisonment, the judge has no option but has to award that imprisonment. Very often, judges have been faced with this difficulty that they would have commuted the sentence and diminished the sentence but for the fact that there was a statutory minimum. So I think criminal laws must always have what is called a periodic review. We are living actually with a penal code which is, if I may say so, of considerable antiquity. We are relying upon an Evidence Act of considerable antiquity. It is not to say that the Evidence Act has not worked. It has worked splendidly. But I think we also need to review laws as a lawmaking exercise. Even the Code of Criminal Procedure, there are so many provisions in this, which today we can actually do a slight leapfrogging. For instance, in relation to committal, which I mentioned, which is completely, the time which is taken before a case is committed and it goes to the Court of Sessions and the Sessions judge frames charges. It is really relevant for you to know time passes. So we can actually fast track many of these steps. And the suggestion from the government that they would like to look at laws for the purpose of reforming the criminal justice system is welcome. It has to be constructively, we have to participate in this constructively to make sure that ultimately we deliver justice, particularly to the marginalized and the poor, in a completely non-discriminatory manner. It should be transparent. It should be open. It should be visible.
Very rightly said, sir, that timeliness is the essence of the criminal justice system and also the scope of Article 21. We need to keep in mind that how one needs to adhere to the timeliness of the justice system. So, with your permission, going ahead to the next question. Shreya Mishra, one of the students again, she tries to know that we are in an accused-centric trial, that we are constantly talking about the rights of accused and how the accused needs to be protected. So in this light, whether the victim is also lost in the criminal justice system. So why the victim compensation schemes are not working, and what could be the measures where the masses of people can be also be made aware about such schemes?
I think definitely the role of space, or the space to be given to victims, must necessarily increase, both in terms of awareness, consciousness, and participation in the system. But we must also know that those who pursue the case on behalf of the victim must never be in danger. This is very important. We are dealing with cases where there can be unequal positions, unequal between a victim and perhaps a person who is actually an accused person. Therefore, it is very necessary for the state to make sure that the victim is always, the victim or whoever is connected with the victim, who is fighting for the victim, is sufficiently safeguarded. This is very important. As far as compensation is concerned, it is the legitimate area for legislation, in my view. And the time has come when, if compensation is itself prescribed appropriately, it could act as a kind of, I would say, relatively low, but still a deterrent in relation to crimes. One of the ways in which you deal with crimes is, of course, punishment. But why is it that crimes are still committed, notwithstanding the fact that there are punishments for crimes? Because there seems to be a risk-taking factor in human behavior, that you can actually undertake the criminal act and possibly will not be able to get punished for it. But if you have also the need to pay compensation, and compensation stratified on certain considerations which must be founded on expert sociological, and if I may say so, expert considerations of how it should be assessed, that would be helpful. It would be very useful, in my view, as an additional chapter for the purpose of criminal justice. And also, likewise, we could even have guidelines for sentencing. Sentencing, again, does not have to have what is called a wide penumbra of discretion. As now judges do believe that there should be a matrix, there should be a score. The thinking has progressed substantially that we must put a score so that it's as objective as possible in the matter of sentencing.
Thank you, sir. The next one is from Yanshu Agarwal. As we are aware, the best bakery case, which is a classic example where flaws and inefficiency of the system of public prosecution had come into light. Concerning this case, would you like to point out a few measures which can be improved in the light of public prosecution?
You see, I would not like to comment on this case because I have not had a chance to either familiarize myself with the content of the subject matter of this case. I have not really studied the record of this case. If I have not studied the record, I would not like to make a comment. I can speak about a case with which I have some familiarity. I have read about it in paper, but that is not the basis for a professional person to make a comment. I'm sorry. I apologize. I won't be able to take that question.
No issues at all. We'll go ahead with the next one. Sir, Simran Upadhyay would like to request that, sir, could you please highlight an article on how to control the scope of judicial discretion so that it is not tainted by personal prejudice?
This is a very interesting question, and we should not run away from the question. We should deal with this question, engage with it. I really believe that the time has arrived for what should be considered as a dialogue or a conversation on some of these aspects. And these are relevant because justice is also a matter of perception. It's very important indeed to bear this in mind, that justice is also how it is perceived and how the lawyer perceives it and how the lawyer carries it to his own client. All these factor, if I may say so, in this question of how justice is delivered. Now, a person may seem to have a prejudice, but in fact have none at all. None at all. And that a lawyer who has had many years at the bar, an experienced lawyer, would be able to tell you that what you are thinking, the judge may be actually thinking out of different other considerations. This is something which has to be understood. Therefore, this is an area where one has to actually, that is why there used to be some training. When judges used to be inducted, there was some training on how to come across, even in the discharge of your judicial functions, in terms of fairness, in terms of even-handedness, in terms of treatment of counsel, irrespective of seniority or whether he is a newcomer to the bar, and that everyone is treated in the same way. These are all matters which carry weight, and they do have a bearing on the perception of justice. I do not think it can be denied that they do not have a bearing on the perception of justice. But this is where we have to work, if I may say so, together. We have to work to see that these are matters of perception which have to be taken. It is an additional responsibility, I'm afraid, which is taken by judges, because they are not only delivering justice, but the way they do it must also inspire a great deal of confidence. The level of public confidence is somewhere linked with perception. Whether anybody says to the contrary, I wish to say no, it is a question of perception. But perception may not be the truth. The point is, perception may not actually be the truth. The person may not be having any prejudice at all, but the perception may be different. Hence, we must therefore converge, if I may say so, in a position where impartiality and freedom from prejudice, A, must be assumed by the legal profession on the one hand, and B, the actions on the other hand reciprocate that faith. You see, this is a system based on trust. If the trust is not maintained, I'm afraid it is going to create difficulties. We're going to make comments. It is based on trust. That trust is based upon, one, us trusting the judiciary or the judges, and the judges reciprocating that trust with that. This is the belief system. So there is an element of, if I may say so, this is an added element in the justice delivery system of how the conduct itself is capable of a perception. This is a very important point, and I do not think that we should run away from it. But it should not be the point for rushing to hasty conclusions either. While I am saying on the one hand that there is a duty to conduct carefully, it is also a duty that we are positive and we don't rush to conclusions. But there might be times when a conversation may be necessary, and that cannot be ruled out. And that should be welcomed, because ultimately the two limbs of a legal system are an independent legal profession and an independent judiciary. And we must know that neither of us have anything to do with the executive. Let us be clear on some fundamentals. Neither the legal profession nor the judiciary is meant to have anything to do with the executive. This is an independent profession. Why is it law is called an independent profession? It is independence of thought, independence of decision making, independence of choice, independence of conviction. This is something where, in my view, a conversation is always possible, always helpful. The attitude must be one where we have to learn to work together for optimization of the judicial value. The optimization of the judicial quotient in the administration of justice is vital for the Constitution. We cannot underestimate that quotient. It is important. How do we optimize it unless we realize how to engage with each other? This is a very vital point. And therefore, I always encourage lawyers, at least I try, that it is very easy to be critical, very easy to come to conclusions, but we don't have any basis to form such conclusions. And as lawyers, we really cannot form conclusions without evidence. Imagine, we are lawyers, we are trained to act on evidence. We cannot come to any conclusion without evidence. That is why I do believe that there are areas where, while we put full faith, there must be reciprocation towards that faith by the way in which justice is dispensed. The conclusion may be one thing or the other. It is not relevant. It is the way in which it is delivered that it is so important.
Thank you, sir. We come to the next question. Dharmalia Ganguly request to know that should India bring legislation on passive euthanasia for the death row convicts who have already been under imprisonment for more than a decade?
No.
Sir, and sir, what could be the things?
No.
Okay, sir. So the next,
because it offends principles of public morality.
Correct. Sir, there are several other comments, several other questions, but
No, I'm ready. I have time. Don't worry.
okay, sir, we'll take the next one then. As just the famous saying of Gladstone, justice delayed is justice denied. Vishwas Agarwal tries to find out that. Could you please tell us your thoughts as per this statement in regard to the Nirbhaya judgment, that what all should need?
You see, justice delayed in any case, any one matter, whether it is Nirbhaya or whether it is any other matter, is itself a form of denial of justice. Delay in justice is a form of denial of justice. But there is nothing called instant trial, instant judgment, instant conviction. It's not possible. Let us also be pragmatic about it. Some amount of time has to be given for the process of law to reach its fair end. This is where Justice Sinha, and I was also a member of that committee, we said we must have a earmark, a period, that from the time of initiation of a case till the time of final conviction by the appellate court, right up to the Supreme Court, what should be the maximum period we should take into account. We thought it should be 3 years. So we said 0 to 3 should be the period. And after that, we should assume that there is an element of denial of justice if it was not over within 3 years.
Like you also mentioned that the role of the judges is not limited to that of the courts, but it also extends to see that how well the compassion, the justice is delivered,
Yes.
and also the principles of humanity is also found in the core values of the criminal justice system. Very rightly said, sir. Sir, the last question which has been pointed out.
In fact, I wanted to mention this.
Sir.
You see, the principles of judicial conduct have been refined over and over. And you will find that the increasing emphasis has always been on gaining more knowledge, on having more exposure to new forms of thinking, having the benefit of new perspectives. And all this involves, as you said, a certain degree of humility. And justice requires one more quality, which is the quality of empathy. Unless that empathy exists, how will you evaluate a situation? How will you evaluate a situation? It needs also an additional factor of transference to be able to understand what could have happened, what must have happened. You see, I remember when I was very, very young and I appeared before the Senior Justice Chandrachud, who was extremely versatile, very, very versatile judge. He could deal with all branches of law. And he also was very accomplished in criminal law. He invariably would even picture in his mind's eye whether the version of a witness could be correct or not, even at the stage of an admission of a case. And I'm mentioning this because, therefore, a judge must be able to transport himself to either a case, the facts of a case, or in relation to the people who are in front of him, to be able to assess what is required.
Rightly said, sir. The last question, which is also from our very own professor at NUJS, Professor Kavita Singh, she seeks your views on that. Why do only trial courts have discretionary power, as you had also mentioned in your lecture, as power of Section 482 of the Code of Criminal Procedure? and why the same cannot be also extended to trial court and remain only with the High Court and the Supreme Court? Sir, your time for it.
Well, you see, I have to be rather candid about my personal opinion, because it's been my opinion as a constitutional lawyer, and I want to be absolutely candid about it. You see, the constitution framers did not really think of exactly what I would say as a hierarchical judiciary. This must be understood. They really contemplated a judiciary of almost parallel, equal competence in all the three tiers, whether it was the Supreme Court, whether it was the High Court, or whether it was the courts subordinate to the High Court. And that is very evident from the fact that we had a very limited number of judges in the Supreme Court when the Constitution was enacted. Then the strength went on increasing. But why is it that we had just a limited number of judges in the beginning? It is because the way in which the Constitution framers perceived was that judges of High Court and the Supreme Court and members of Judiciary, more or less, are involved in the process of adjudication. This becomes very clear if you look at one article, Article 32 within brackets 3 of the Constitution. Article 32(3) of the Constitution enables Parliament to frame a law by which it can invest courts which are subordinate to the High Court to exercise the same powers as are vested in the Supreme Court. This is a very important provision. And this gave me the requisite understanding that really qualitatively, what should India do as a forward-looking country? We must actually bring about forms of parallel, if I may say so, equal ability in the courts, which are called district courts, and the High Courts, and the Supreme Court, and bring them at par as far as status is concerned. While one can be an appellate court over the other, but I do believe that there is a need to revisit this, because the way in which, in reality, it has become like almost a pyramidical structure, which is not what the Constitution really intended. Therefore, the serious issue which arises is, again, and it is a matter of considerable comment, that why is it that members of, let us say, the level of magistracy are reluctant to pass orders releasing, enlarging a man on bail? Why are they? Why do they? The reason being that they expose themselves to some adverse comment or criticism. So we need to also free, we have to free judges of any possible fears which they can experience in the administration of justice. This is very important. And therefore, we have to all work together to make this into an extremely capable, and it has been a capable institution. There can never be, in no part of the world will you ever see there's something called a utopian institution. But we have progressed well, but we must proceed forward to look at the problems we have and look at them scientifically, rationally, and effectively. Therefore, when I asked for a committee in relation to compensation, I said it should be by an expert group of sociologists. If suppose it is scale of because we need to have economists, we need to have sociologists who will give you the correct figures by which compensation can be assessed in respect of behavior. We need to also have another part of our criminal justice mission, which is reformation. And do you know, I just need to mention one factor. There was a superintendent of prisons in Madhya Pradesh, whom I met in 1981. And he took his job so seriously that he believed that everybody had a chance of reformation. And he, long before anybody else had undertaken prison reforms, had actually changed the lives by communicating with people inside the prison effectively. So these are all possible goals which can be achieved. And I think our role must be how to achieve more, how to connect more, how to communicate more. You see, the farther we move away from each other, the greater will be the scope of distancing in the matter of justice. So physical distancing is very different in COVID from what is actually, shall I say, distancing in justice terms.
Thank you, sir. Very rightfully and correctly said. Just to appraise your kind, sir. In West Bengal, in this current situation of the pandemic, inside the prisons, a work has been started about preparation of masks, which can be also distributed. Right? You correctly pointed out in saying that the law must connect to the society, and that is the purpose for which we should bring in the other stakeholders, the economists, the sociologists, also the psychological aspects of the accused as well as the victims in the entire criminal justice system. So I am sure it was a very insightful discussion from your end. I am very correctly can come out to this conclusion that the entire legal fraternity, our faculty, students have learned a lot. With your due, with your humble permission, I now request our convener to give the vote of thanks.
I, Dipanshu Agarwal, the convener of the Society for Advancement of Criminal Justice, would first of all like to thank from my heart Mr. Gopal Subramanium sir for enlightening us about the criminal justice system. Sir stressed upon the structure of public prosecution, the access to justice, and the role of courts in maintaining the sanctity of this system. Sir also emphasized upon the need to ensure speedy disposal of cases, which will reduce the burden of pendency on courts. He also shared his personal anecdotes regarding Justice Verma Commission and his experience in courts over the years. He also emphasized on the need for periodic review of criminal law legislations. It was indeed a pleasure listening to you, sir. We are sure this lecture will help legal fraternity at large in the days to come and will provide them various themes over which academic discourse can be promoted. At this note, I would also like to thank Andrew sir and Ujwala ma'am from the chambers of Mr. Subramaniam for their active involvement which helped us in organization of this session. Secondly, I would like to thank our faculty advisor Surja sir for agreeing to moderate this session, providing us with his views on the criminal justice system, and also for helping us organize this session in a very smooth and efficient manner. I would also like to thank our Honorable Vice Chancellor sir, our faculty advisor Faisal sir, mentor in Capita ma'am, and all the faculty members of NUJS who supported us actively in organization of this lecture. Lastly, I would also like to mention the contribution of the members of the organization committee who actively participated, and without their support, this session could not have been successful. And finally, I would like to thank the members of the audience for participating in such an interactive discussion and helping us achieve our objective to promote criminal discourse to legal fraternity at large. We are sure that this lecture will help across legal fraternity across large, and this recording will help them in the years to come. Thank you.
Thank you. Thank you very much. Thank you.